All right. I would now like to move on to speaking about the case called Colorado Civil Rights Commission versus the Masterpiece Cake Shop. It was handed down by the United States Supreme Court in 2018. And here we have something which the court talked about in Obergefell and kind of sensed might come down the pike. It came down the pike very quickly. Here we have a contest between rights claimed under the First Amendment and rights claimed as part of the Equal Protection Fundamental Rights. Now, before we get into that, we should talk a little bit about the First Amendment, freedom of speech and religion, which is good because as we move into notes on week 7 and 8, we'll be dealing extensively with the First Amendment. So this will kind of break the ice and get us into that. The First Amendment to the Constitution basically guarantees freedom of religion, freedom of speech, freedom of the press, freedom of assembly, and the right to petition the government. The 5 freedoms it can be called. Right? First Amendment, in terms of its language, is very simple. Congress shall make no law respecting an establishment of religion, or in prohibiting the free exercise thereof, or abridging the freedom of speech, of the press, of the right to the people to peaceably assemble and to petition the government for a redress of grievances. It's not 100 words, but yet it contains a whole host of ideas and concepts, all of which have to do with the idea of freedom of thought, freedom of conscience, freedom of expression, the idea that as human beings we should have the right to think what we want to think, believe what we want to believe, establish our lives upon our thoughts and belief, and to then communicate those beliefs and thoughts to others. This is a very, very important subject to the people who are writing the Constitution. If you go back to the history of the founding of the 13 American colonies, more than half of them were founded by people who were fleeing the very severe restrictions on religious freedom that existed in England in the 17th and 18th centuries. And they basically came to this wild country on the other side of the ocean in order to be able to hold their own thoughts and beliefs and to have their own religious practices. These would have been the grandparents and great-grandparents of the people writing the Constitution, maybe great-great-grandparents. But these concepts were very much still built into their thought process, built into how they arranged their governments in the various states and how they saw life. So very important things. Freedom of speech, again, is your right to think and say what you will, but it also applies to social groupings. And by saying freedom of the press, it applies not just to individuals, but to companies, to groups of people, to societies, to religious groups, to people who make a living by spreading information and news. Freedom of religion, the Bill of Rights, deals with it from 2 different aspects. And it's important to understand what they are because otherwise you get hopelessly confused trying to read and look at the freedom of religion cases. The first thing that they were absolutely sensitive was that they did not want the federal government to establish an official state religion. After the Protestant Reformation in Europe in the 1500s, there was a period of time pleasantly called the 30 Years' War, during which there was brutal, vicious fighting between various Christian groups and breakaway groups and the existing Catholic Church. And they basically fought until they wore themselves out, had bankrupted their economies and almost destroyed their societies. And finally, an agreement was entered into particularly by the German states that were part of the Holy Roman Empire, that basically said that various kingdoms, duchies, dukedoms, states were each free to have their own religion, that was not a reason to make war against a neighboring state, and that the basic rule would be that the religion of the prince would be the religion of the state and the religion of the people. So if you were a Catholic living in one of the northern German states, and your prince decided that he was going to be Lutheran and remain Lutheran, you had two choices. You either converted to Lutheranism, or you worked your way down to Bavaria, where the princes of Bavaria determined that they were going to remain Catholic. That theory, of course, came to England under Henry VIII, who, in an argument with the Pope over whether he could divorce his first wife or not, severed the Church of England from the control of the Pope in Rome, basically made himself as king and sovereign of England, also the head of the church in England. And from that point forward, even to this day, there is an official Church of England in England, and during the 15 and 1600s, people were executed, severely beaten, tortured, jailed for refusal to participate in the official church. And the interesting thing is the official church kept changing. It developed over time, so that what it was under Henry very quickly morphed into very different things as different other kings and queens came along. So not only did you have to follow the official church, you had to keep up with the changes. As different people came to power and they were tinkering with the official church, you had to keep up with it and go, or you would be proclaimed a heretic and you would be subject to the death penalty. The result of the severe religious rules was that the Puritans, the Pilgrims came to Plymouth, the Puritans came to Boston, the Catholics came to Maryland, the Quakers came to Pennsylvania. There was a tremendous exodus out of England by people who did not want to submit to the king's religion or to be subject to the constant political machinations or changes in their religion. And the only respite they had was to get away from the mother country, to get as far away from the king's regulations. So the writers of the Constitution were acutely aware of this, and the first thing they put in the First Amendment that the Congress cannot establish a religion. Secondly, they said the Congress cannot pass any laws prohibiting the free exercise of religion. Now, this is looking at the issue from the other side. So we're now saying, we'd say that the government cannot have an official religion, but now we're turning the coin around saying, nor can they prohibit any type of religion, that whatever people want to believe and practice, they have the right to do so, and the federal government has no say in stopping that, in preventing that. There is a great deal of discussion about the idea of separation of church and state. And when we get into the First Amendment, a lot of the cases we talk about are going to kind of tiptoe around this idea. Separation of church and state does not appear in the Constitution. It does not appear in the First Amendment. It does not appear in the Bill of Rights or in any of the other amendments. That idea comes from a letter that Thomas Jefferson wrote to a Baptist community, a Baptist church in Danbury, Connecticut. The Baptists were not particularly beloved by their Puritan or Congregationalist neighbors in Connecticut, and the Baptists of Danbury were very much fearful that this new government would take the side of the Puritans, of the majority of religious believers in Connecticut, the religion of the majority of believers in Connecticut, and would not stand up to protect the rights of the Baptists. And Jefferson, in writing to them, said that he saw the Constitution, the First Amendment, as prohibiting Congress from establishing any religion. And he basically said that the Congress should be able to make no law respecting the establishment of religion or prohibiting the free exercise thereof, thus building a wall of separation between church and state. So there is no real idea, no legal idea of separation of church and state in the Constitution. It's something that Jefferson was using as a concept to reassure this religious minority in Connecticut that the new government had no intention of prohibiting their beliefs, their practices, and had no intention of trying to take sides against them and supporting the majority of people who had other different religious beliefs in Connecticut. Since then, of course, that phrase has been brought into the popular parlance, and it has even worked its way into some court decisions to be used and abused over the years. And when we get into week 7 and 8, we'll talk about that in more detail. The First Amendment did not apply initially to the states. The state of Massachusetts had an official church well up into the 1920s. What had been the Puritan church evolved into the Congregational church, and it was a state-supported church in Massachusetts. The government gave money to the church. They collected a tithe or a church tax from the people to support the church. By the time you reached the 1800s, you did not have to be a member of the Congregational church, but I believe you still had to pay taxes to it, even if you weren't a believer. So this was, again, with many of the other parts of the Bill of Rights that we've spoken about already, the First Amendment was not initially seen as applying to the state governments, but only to the federal government. And it was only through the 14th Amendment, through the idea that we've talked about already of incorporation of the Bill of Rights, that the First Amendment in the late 1800s and through the 1900s came to be applied to the states, as it was applied from the beginning to the federal government and to laws and acts of Congress. All right. The government is officially supposed to be neutral when it's dealing with religious belief and expression. It's not supposed to give any benefit to one religion over the other. It's not supposed to interject itself into arguments within a religion or between different religions. All right. We need to, before we get into Masterpiece Cake Shop case, we need to talk about freedom of speech a little bit also. Speech is the idea that you can state or say what you want to say without the government controlling or regulating it. And it covers not only spoken or written words, but it also covers conduct. Basically, any way that you express yourself, be that through speaking, writing, singing, artistic endeavors, wearing armbands, carrying flags or banners, putting signs up on or symbols up on your property, all of that is seen to be protected by the First Amendment. So expressive conduct is the idea that you're doing something or holding up a symbol that has meaning, even though no particular words might be spoken at the moment. There is also the idea that the First Amendment not only prohibits Congress and the government from keeping you from speaking, so they can't prohibit you from speaking, but it has also grown to encompass the idea that they cannot force you to speak. During the 1940s and 50s, several religious groups who did not believe in oaths brought cases to the Supreme Court saying that their children should not be required to say the Pledge of Allegiance in public schools or to salute the flag in public schools. And the Supreme Court basically agreed with them and said, yes, that in effect in the public school, that is the government trying to force you to do a certain type of speech that you may not want to do or you may not believe in, and that they cannot be required to do that if it violates your own principles, or particularly if it violates your religious beliefs. So there is this idea of that freedom of speech kind of works in two directions at the same time. The government can't stop you from speaking, nor can they make you engage in speech or in some kind of expressive conduct that you don't want to engage in, that you don't believe in or don't want to be part of. All right. Under the 14th Amendment, equal protection, due process, freedom of speech, First Amendment has certainly come to be applied to the states, and certainly today in the federal courts you can bring actions against your state and local government, not just against the federal government, to enforce your rights under this. Need to talk a little bit about civil rights. In 1964-65, Congress worked upon and enacted the Civil Rights Act, which the 14th and 15th Amendments of the Constitution had given them the power to do, to enforce equality among people and to ensure there be no discrimination based on the different criteria that Congress may set. And many states followed, passed their own laws, some of which were more expansive, considered more areas that could be violations of civil rights than the federal law did. And that's a permissible concept under our system, that if a state wants to grant you more rights than the federal Constitution does, the state is free to do that. However, once the state does that, they must treat all people equally under that right that they have created. Many states have what are called civil rights commissions. The state of Rhode Island has one, where basically if you feel that your civil rights are being violated, that you're being discriminated against because you are part of one of the suspect groups, suspect categories, classifications, where you can, without actually beginning a court case, you can bring an administrative action to have somebody fined, and to have an injunction issued to force them to stop whatever practice it is that you think is discriminating against you. Most of these statutes, up until the 1990s, 2000s, they basically said that there could be no prejudicial treatment based on categories that were based on race, natural origin, religion, age, sex. All right. And when we get into the transgender cases we'll talk about how the idea of the word sex has evolved from the 1960s and 70s into the 2020s, with some differences. When your rights are violated as a citizen under your state civil rights laws, as I said, you usually have a civil rights commission to which you can go and you can seek an administrative remedy for your violation of rights. And actually, you would have to begin there. If your state affords you those privileges, the basic court rules that have been established over the centuries say that you must exhaust your remedies. You would have to apply to these folks first to seek a remedy for the wrong that was done to you. And the federal courts would only get involved after you had exhausted all your state remedies and felt they still were not upholding your constitutional rights. So what happened in Masterpiece is that we have, for the first time, the idea of same-sex marriage being a fundamental right coming up head-to-head with the idea of First Amendment freedoms that may be practiced by an individual. And it gets very, very interesting, and it gets very, very complicated. And as we go through the case, we'll find out that the court did not really do a good job in handling this. They kind of batted this issue off on a technicality without really answering the fundamental questions. And the fundamental questions are still there, and they are going to keep coming up. And as I said with Obergefell, I'm sure there are cases working their way through the lower part of the court system now to bring up these issues again. You basically have two different things here. Most civil rights statutes forbid a business, even a private business, as long as it's open to the public, from denying services to someone based on the suspect classifications. Now, under Colorado, they had amended their laws so that sexual orientation was one of the suspect classifications. So basically, this idea is that even though you have a private business, you're the owner of a movie theater, you hold yourself out to the public to buy tickets, to pay money to come in and watch the movies that you're showing, then you cannot discriminate if you see a same-sex couple coming in to buy tickets, and they obviously are a couple or a romantic couple, then you have no, or even if you don't know, you just suspect that, Under the Colorado definition of civil rights, you had no right to deny them services the same way you could not deny services because somebody was black or Oriental, or deny services to all women as opposed to granting them to men. And that is, since the 1960s, this has been a fundamental concept in our law, rarely ever questioned at this point in time. Clearly, if you walked into a supermarket, you could not be put out because of your race, your gender. In most states today, you couldn't be put out because of your sexual orientation. You couldn't be put out because of your marital status. So there's no doubt that the law is saying that discrimination, even by private property owners, private merchants, private business people, is prohibited, and that the states and the federal governments have a right to enforce laws prohibiting this. At the same time, the states cannot prohibit speech merely because someone finds it offensive, hurtful, stigmatic, unreasonable, or undignified. All right? The bedrock principle under the First Amendment is that the government cannot prohibit the expression of an idea simply because society or parts of society find it disagreeable or offensive. In Masterpiece Cake Shop, the Civil Rights Commission of Colorado was forced to weigh a person's right to religious freedom and freedom of speech against the 14th Amendment and civil rights statutes of the state of Colorado of individuals not to be discriminated against because of their sexual orientation. The basic facts of the case are that a gay couple planning to get married came into this cake shop that was apparently known in the area as being one of the better shops for making wedding cakes, that the master baker was quite an artist, could do all kinds of wonderful, interesting things with cakes. And this couple came in asking that the baker create a wedding cake for them, for their upcoming marriage. The baker, who was a committed Christian, said that his religious beliefs did not allow him to participate in a marriage ceremony between same-sex individuals, and he refused to make a wedding cake for the couple. Now, the courts have long made a distinction between belief and actions, and while you can believe anything you want, the court has recognized limits to the First Amendment in terms of what can you engage in as an activity. You could believe that it is necessary to sacrifice a virgin to the moon god every full moon, and that you must find a young victim that you can kill and drain their blood in order to make your god happy. You can hold that belief in this country. You cannot practice that idea. You cannot put that into practice. In the past, the Church of Latter-day Saints, which originally allowed for polygamous marriages, marriages of one man to more than one woman, ran into this when Congress basically made polygamy illegal. And the courts upheld that idea that the Congress had the right to define marriage and to say that marriage could only be between two people, and that therefore the church had to abide by that. And even though religiously at the time they believed that a man could have more than one wife, they were not allowed to practice that, and the states were not allowed to grant marriage licenses to multiple marriages. All right. So today, we have the situation today where if a restaurant or a hotel owner attempted to deny services to a person based on their race, their civil religious beliefs, their sexuality, the establishment owner would be in violation of federal and state civil rights laws. They could be fined, they could be jailed, and injunctions could be handed down against them to make sure that in the future service could not be denied. The one difference here, because in some respects, many people say that this should be a easy case. They came in, they asked for service, they were denied service, boom, the guy violated their civil rights, he's in the wrong. The one difference here is that you have this idea of the First Amendment not only protects your religious beliefs, but also protects the idea that you can't be forced to make statements in which you don't believe. So part of what was going on here, the people that were the lawyers who were representing the baker, not only said that we're pushing his religious beliefs to the edge of their limits here, but by asking him to make a cake, you're asking him to perform an artistic endeavor that he doesn't believe in, that he believes it's wrong for him to do. And this is not a simple matter of going into Stop and Shop to buy 3 cans of peas and Stop and Shop saying to you, and I didn't use them as an example of for any reason, it just came out of my mouth without thinking, because they're my favorite store. How's that? So don't tell them I said that. I don't want them suing me. I have no knowledge of Stop and Shop ever violating anyone's civil rights. But as an example, if a supermarket were to say, no, you can't come in and buy a can of peas from our store, there's no artistic involvement in that. There's no freedom of speech involvement in that. It's very clear that that's covered by the civil rights laws, and they cannot prohibit somebody from entering in and engaging in commerce with them based on these suspect categories. However, it gets much touchier. If a neo-Nazi goes to a Jewish artist and says, I see that you paint historical artworks, you paint portraits of historical people. I want you to paint a life-size portrait of Hitler that I can hang at my neo-Nazi meetings. Can the law force that Jewish artist to basically create that portrait of Hitler? And I would say clearly not. Are we discriminating against the neo-Nazis? To a certain extent we are. They have the right to believe their crazy ideas. The court has been very clear in the 1970s and 80s when the neo-Nazis wanted to march in different places, even through Jewish neighborhoods. The political authorities had to allow them to do it because they had a certain right to expression, freedom of speech. Their beliefs almost rise to the level of a perverse religious belief. And here we are saying, well, because of your belief system, we're not going to provide you service. I'm not going to be an artist for you. You've got two conflicting fundamental rights going on here. And I think in that case, most courts would probably have clearly found that the artist did not have to paint the painting of Hitler for these people just because they came into his shop or his studio and asked him to do the same. All right. It is a quandary. It is a difficulty, and the court did not really address the matter fully here. One of the things that happened in this case, which if any of you get involved in politics or you get on boards and commissions in the future, become involved in the affairs of your cities or towns, be aware of this because it is a reality. The Colorado Civil Rights Commission, a number of the commissioners, when they were hearing this matter, they were openly contemptuous of the baker's religious beliefs. They put in the record some fairly despicable things about Christians and Christianity and archaic, bizarre belief systems, and really evidenced a severe prejudice against not just this particular situation, but against religious beliefs as a whole, and particularly against Christian religious beliefs, fundamental Christian religious beliefs, and they were what's the word I want here? They were self-assured enough that they had no issue putting this in the record. So, and if you know anything about law, whenever you file an appeal, and the Colorado board was appealed to the Colorado state courts, and eventually from the Colorado state courts into the federal court to the Supreme Court, everything that has been said, everything that has been done before is all reduced to writing, and it is what's called a record, and it follows the case. So all of this was there for the clerks of the Supreme Court judges to dig through and find, and it became clear that there was that going into this hearing, there was an obvious anti-Christian bias on the part of a number of the commissioners, so that the baker was already behind the 8 ball before he even got to the hearing. that these people showed contemptuousness towards his belief system, and it was quite obvious that they weren't open-minded about hearing the facts of the case and trying to make some kind of rational decision based on the law and the facts, but they were operating out of their own prejudice. Because of this, the Supreme Court was able to dodge the major issue in this case and basically overturn what had happened and send it back down to say that we are overturning the case based on the fact that there was obvious religious prejudice going on the commission, and that the commission could not have come up with a correct answer in any circumstance. But that did not answer the real question that is here, which is, when my First Amendment rights come up against your rights of equal protection and civil rights not to be discriminated against, who wins? Who controls? How are we going to handle this? It become, and again, this is going to grow. It's going to get bigger. A number of religions do not believe in same-sex marriages. Can they be forced to perform them? If there is a fundamental civil right to have a same-sex marriage, if they are witnessing if these religious groups are witnessing the marriage licenses of same-sex couples, if they are performing ceremonies for same-sex couples, usually for a fee, so it's not only a religious, but it's a business proposition, can they be forced to perform a marriage for a same-sex couple when their belief system says, we can't abide by this, we don't agree with this? It goes even further. A number of the Roman Catholic Church, the Orthodox churches, do not believe in having women prelates and having women priests or women ministers. All of these organizations are now 501c3 charitably exempt organizations under the tax code. They have pretty much recognized the reality that under the Johnson rule, they're not allowed to engage in specific political campaigns if they are a charitable corporation recognized by the IRS and availing themselves of charitable contributions. Could they be forced to grant equal rights to women? And could a ruling come down that we're going to take away your tax exempt status unless you agree to have women ministers? The possibilities for conflict between the government and religion are growing here. And as the society changes, as the society moves away from its Judeo-Christian roots and histories into a much broader belief system in terms of what's acceptable and not acceptable behavior, these conflicts are only going to grow. And these are things that during your generation are going to have to be decided, I think. And the courts have begun to see these issues, to recognize them, but to come up with clear-cut answers to them, it has not happened as of yet. The case went back down, and based on the Supreme Court's calling out the Colorado Civil Rights Commission for unfair practices, the Baker turned around in federal court to sue the state of Colorado. And it became an absolute legal mishmash, which somewhere towards early 2019, the Attorney General of Colorado finally just said, we're giving up. We're dismissing everything. If the Baker dismisses his federal case, we're going to dismiss the case against the Baker. Everybody go home, and we'll leave this for someone else to decide another day. Now, since that time, another person has gone to the same baker in the same shop. This was a person, a transgendered person, who went in knowing that this was a baker who had said he had these religious beliefs. And this person had transitioned from being a man to being a woman and wanted a transition party cake to be created by the baker. Wanted something created that would acknowledge and would celebrate the transitioning from man to woman. Again, the baker said, no, I can't do this. It's against my religious beliefs, and I have not had the time in the last few months to really follow it, but the last I saw, that case was still banging around the court system in Colorado, before the Colorado Civil Rights Commission. So, as I said, these issues are not settled. They are not done. They are not resolved in any way, shape, or form at this point in time. And the concept of where are the lines? Where does equal protection and civil rights come up against First Amendment rights? And how do we decide between the two different parties in these types of situations? All right, that is it for this. I'm going to do a separate little segment on how the courts have been handling transgendered rights up to now. So stay tuned for that.